Hey everyone, it's Thursday, it's 5 p.m., and you are at the bar. I'm Inez Stepman from Independent Women's Forum.
And I'm Jennifer Braceras with Independent Women's Law Center. Time to grab a cocktail, belly up to your laptop, and join us for the fourth virtual happy hour conversation about issues at the intersection of law, politics, and culture.
That's right. Today we are talking about the sadly relevant subject of court packing with Mike Davis from the Article 3 Project and our very own Erin Hawley, Senior Fellow with Independent Women's Law Center. Just to tee up this issue a little bit, since 1869, the court has consisted of 9 justices, 8 associates, and 1 chief justice. Over the past 150 years, Americans have really adopted this norm, right, that there are 9 Supreme Court justices. Recently, though, as President Biden has established a bipartisan commission, supposedly bipartisan commission to study Supreme Court, what they're calling reform. And among other things, they're examining the size of the court and the justices' lifetime appointments. So why now, Jennifer? Why is this something we're talking about now?
Well, that's a good question. Calls to expand the court have been around for a very long time, primarily from people who, for one reason or another, don't like certain court rulings. The premise behind expanding the court is really the fundamentally anti-democratic idea that unelected judges are supposed to make law or just rubber stamp laws that conflict with the Constitution. Now, as you know, that's not the role of the courts in a democratic society. And for most of our history, both Democrats and Republicans understood that and rejected the idea of court packing as a threat to our separation of powers. In fact, when Franklin Roosevelt tried to pack the court in the 1930s, Democrats rejected the idea as an attack on our constitutional norms, which, in my view, it remains today. But in recent years, we've seen more and more Democrats warm to the idea of court packing, mainly because they're upset that the Republican-controlled Senate refused to confirm Barack Obama's nominee of Merrick Garland to replace what I know Mike refers to as the late, great Justice Scalia. As everyone knows how that played out, Majority Leader McConnell did not move that nomination forward. Ultimately, we had an election. The people voted. Some huge proportion, maybe Mike will remember the number, but some huge portion of people who voted in that election said that they based their vote on the Supreme Court. Donald Trump won the election, and ultimately in January of 2017, he appointed now Justice Neil Gorsuch to that seat. And really, ever since then, Democrats have been demanding that we increase the number of justices on the court, essentially to neutralize Gorsuch and Trump's subsequent appointees, Justice Kavanaugh and Justice Barrett. Now, it is true, Donald Trump was fortunate to have 3 appointments during his presidency. For some reason, the Democrats view this as illegitimate or unfair, even though this is precisely how our founders intended it to work. They intended there to be elections, and then for the person who was elected to nominate people to the court. The Senate, of course, has a role to play. The Senate can confirm the nominee, the Senate can reject the nominee, or the Senate cannot move on the nominee. All of that is within the normal bounds of politics and within the rules. But for some reason, the Democrats think that wasn't fair. And so now they want to expand the court so that they can immediately neutralize President Trump's appointees.
Yeah, I really want to underscore that difference between the normal political process, no matter how rancorous or partisan, right? Obviously, we had what we might call a norm of politics whereby particularly before Justice Bork's failure to be confirmed, Judge Bork's failure to be confirmed to the Supreme Court, we had this norm of civility and bipartisanship in the Senate confirmation process, but that was really an internal body of Senate norm, right? It was something we were used to, whereas This is very different. Breaking this norm is breaking a norm of independence between the different branches of government. I think it's really important to underscore how different that is. Politics, the sphere of politics, is supposed to stop at the doors of the Supreme Court. The confirmation process is supposed to be political. Now, political could mean civil and bipartisan, or it could mean yelling at each other in a deeply partisan process, the way that it has turned out to be for the last few decades. But nevertheless, that confirmation process is supposed to be a political act, whereas the politics are supposed to stop once the justices are actually appointed and sitting on the Supreme Court. They're no longer supposed to be a creature of the other branches, of the elected branches. They're supposed to exercise that independence, which is why I think court packing represents such a more important violation of a norm than something like how rancorous our confirmation process has gotten over the years. But, you and I can talk about this for a while, but I think it'll be much better if we bring up our first guest, Mike Davis. Mike Davis is the founder and president of the Article 3 Project. He previously worked for Senate Judiciary Chairman Chuck Grassley, where he served as a staff leader for the confirmation of Justice Brett Kavanaugh and a record number of federal circuit judges. He also previously clerked for Justice Neil M. Gorsuch, both on the Supreme Court and then previously on the Court of Appeals for the 10th Circuit, where he was previously seated. He grew up in Des Moines and graduated from the University of Iowa and Iowa Law. So, Mike, thank you for joining us at the bar, and welcome.
Thank you, and thank you for having me.
So, let's start with the most basic thing. You heard what Jennifer and I were chatting about, but why is court packing a bad idea?
Well, you guys said this. We've had 9 justices on the Supreme Court since 1869. Before 1869, that number used to fluctuate. It fluctuated anywhere between 6 and 10. But the reason it fluctuated, it was because Supreme Court justices used to literally get on their horses and ride around the country. They rode circuits, and they had a tremendous burden. And so you can understand why you would add justices as our country grew, because you're putting this tremendous burden on Supreme Court justices to ride their horses around the country and hear appeals and ride circuit. And so since 1869, we've had 9 justices. We've had the courts of appeals, the U.S. courts of appeals, since 1891, and we have stopped having active Supreme Court justices ride circuit. We don't ride circuit anymore. You'll see retired Supreme Court justices like Justice O'Connor used to do this, where she'd go sit on 3-judge panels as a retired Supreme Court justice. But there's just no need for more justices right now. They're not writing circuits, and there's not an increase in caseload at the Supreme Court. Actually, the caseload is getting smaller. They hear less than 100 cases per year for oral arguments. So there's not a practical reason to increase the number of justices on the Supreme Court. It's purely about Democrats trying to grab power. It's a power grab.
Let me ask you, that brings up a question I have about an article that recently appeared. I think it was in Bloomberg Law, where the authors suggested that, to your point, that the court doesn't hear that many cases right now. And these authors suggested that they should hear more cases, and that is a reason for adding more justices, that somehow if we got up to the number 15, then they could sit in panels the way the courts of appeals do and hear more cases. What do you think of that?
It's just an excuse to pack the court. It's an excuse by Democrats and their left-wing allies to grab power. See, here's the issue. So President Trump, his biggest accomplishment as president was to appoint a true constitutionalist majority on the Supreme Court, the first time we've had one in more than 80 years. And so you never heard Democrats talking about court packing when non-constitutionalists ran the court for 80 years. But now that we have a 5-4 Clarence Thomas court, you start to hear liberals complain about the court. So they want to pack it. They want to change it. And so instead of having a court that's 5-4 constitutionalists, 6 justices appointed by Republicans, 3 appointed by Democrats, now you see Democrats, now that they have the White House and they have the Senate and they have the House, they have full control of the political branches of the federal government. The only thing that's stopping them, the only check on their power, is a 5-4 constitutional Supreme Court. And so you see this with COVID restrictions. You see these Democrat politicians across America would have us kicked out of our houses of worship based upon no science because of, their imaginary fears about COVID. And so 5 justices on the Supreme Court stepped up and said, you can't do this. You cannot kick people out of churches because of COVID, yet people go on with every other aspect of their life. You can't discriminate against churches. And so that would not have happened if we didn't have a 5-4 Clarence Thomas court, if we did not have a 5-4 constitutionalist court. Democrats don't like that there is a check on their power. They want full control. And the only thing that's stopping them is this court. So that's why we're hearing about court packing.
Thank you for bringing up riding circuit, by the way. I love thinking about, for example, Andrew Jackson, who went on to be president. He was a judge for a while, and he exactly rode circuit. Like, it's hard for us to imagine that judges used to be much like the sheriffs of the Old West. They would sort of ride into a town and hear the town's cases and then ride back out. So thank you for that visual image. But to your deeper point, right, that this is really a political move to shift the sort of dynamics of the court, because one side feels that they have lost essentially the political game for the court, even though I would argue, we dealt with being on the losing side, as you say, for 80 years. Constitutionalists dealt with being on the losing side politically of the confirmation battle. But in any case, they've decided that this court is somehow illegitimate because they finally lost that political process that Jennifer and I were talking about. But it turns out that even Justice Ruth Bader Ginsburg agrees with you, Mike, right? We have this video clip of her laying out why she thinks packing the courts it's a really bad idea.
I have heard that there are some people on the Democratic side who would like to increase the number of judges. I think that was a bad idea when President Franklin Delano Roosevelt tried to pack the court. His plan was for every justice who stays on the court past the age of 70, the president would have authority to nominate another justice. If that plan had been effective, the court's number would have swelled immediately from 9 to 15, and the president would have 6 appointments to make. You mentioned before the court appearing partisan. Well, if anything would make the court appear partisan, it would be that. One side saying, when we're in power, we're going to enlarge the number of judges, so we will have more people who will vote the way we want them to.
So obviously there she raises the idea and says it's a bad idea, raises the idea of expanding the number of justices or to put in limits based on age or any other way of sort of moving folks artificially or early off the court. On a court with dozens of members potentially, because we know that if this happens, right, it's not going to stop with one round. If the Democrats pack the court, next time Republicans are in power, they'll pack the court further. How will that change the court, Mike, for the worse?
Well, you have Justice Ginsburg, as you just showed, the late Justice Ginsburg, saying that it would make it political. You also have Justice Stephen Breyer, another Democrat appointee on the Supreme Court, who has recently come out and said that court packing is a bad idea because it would politicize the court. So two of the last 4 Democrat appointed justices on the Supreme Court have made the highly unusual public denouncements of court packing. And the reason is because it would politicize the courts. We would turn the judicial branch, the Supreme Court and the judicial branch, into another political body. And it would lose legitimacy. People would stop having confidence in our federal courts, and we would become a banana republic. Like you said, it would never end. We would just keep packing and packing and packing and packing, and the Supreme Court would just become a joke.
I think that size really makes a difference, because when you have a court of 9 or fewer, it allows the justices to know each other on a personal level and to be collegial in a way that large bodies like the United States Congress often aren't. And, you saw the friendship of Ruth Bader Ginsburg and Justice Scalia. For the most part, all of these men and women get along fairly well. And I think that if you were to go beyond 9, even just, looking at it from a practical standpoint, if you had 15 or 20 or 25 justices, what you'd start to have are caucuses and coalitions. And the justices would not know each other as personally. These coalitions, they would cut deals, and they would look for ways to get people over to their side in a way that's not necessarily based on reason, that's based more on politicking. And that is not the way a court is supposed to operate. That is the way a legislature operates. Courts are supposed to operate by reason and logic and the rule of law. But when you expand the number of people, I think it inevitably devolves into politicking, which is a problem.
Yeah, I agree. I mean, we've had, when I clerked there to help Justice Gorsuch get set up on the Supreme Court, it is a very collegial place. The late Justice Ginsburg, all of them, they were all very welcoming to Justice Gorsuch and his law clerks when we came in. Justice Ginsburg gave Justice Gorsuch her law clerk manual for Justice Gorsuch to use for his law clerk manual as a template for his law clerk manual. Each set, and Erin can talk about this, each set of law clerks for each one of the justices has lunch or coffee or tea with each one of the justices over the course of the year. It's very much a family atmosphere. They may disagree strongly on the law, but it's not a political body. People get along very well. The law clerks get along, the justices get along. The justices treat the other law clerks with respect. It's a very special place. It's one of the few institutions left in America, in our American system, that actually functions properly. And the Democrats, many Democrats who are advocating court packing, want to destroy that because they know that the Supreme Court is the final backstop. It's the one thing that is preventing Democrats from grabbing power, and they don't like that. Remember, our Constitution is a loan agreement between the people and our government. We loan the government specific and enumerated powers, and in return, they promise to protect our liberty. They promise to protect us from mob rule. And somehow, over the course of the last 80 years, we've flipped it on its head. Instead of the federal government being a limited branch of government with limited powers, we've flipped it on its head where the federal government has all powers, unless the Constitution says that they don't. It's just totally flipped on its head. And when you have constitutionalist judges who are going to start to say that the federal government doesn't have the power to do what the federal government proclaims it has the power to do, I think that terrifies the left. And I think that's why you're seeing this court packing, this court packing scheme coming out of the left, out of the demand justices of the world, since President Trump transformed the Supreme Court into a truly constitutionalist court.
To engage in exactly what you're talking about, Mike, I'd like to bring up Erin Hawley. Erin is an expert in constitutional and administrative law, the separation of powers, which is so relevant to this discussion, as well as religious liberty. She's a former law professor, and she was a clerk to Chief Justice John Roberts. So like you, Mike, she knows about the collegiality behind the scenes at the Supreme Court. Erin writes and lectures widely on the Supreme Court, the administrative state, as well as civil justice reform. Welcome, Erin.
Oh, I think you're on mute, Erin.
Yep.
Thanks so much for having me.
Zoom era problem.
Excuse my at the bar is a Diet Dr. Pepper, so no excuses.
There you go. I'm not as good as you. I'm having a little vodka and seltzer water. So perfect summer drink as we get
beer over here.
Cheers, everyone.
Cheers. So, Erin, we're going to start. We're going to play this little clip of Joe Biden when he was a senator, talking about this very issue, and I'd like to get your reaction to it. So take a look.
President Roosevelt clearly had the right to send to the United States Senate and the United States Congress a proposal to pack the court. It was totally within his right to do that. He violated no law. He was legalistically absolutely correct, but it was a bonehead idea.
So what do you think about that, Erin? I assume you agree with them that it was a boneheaded idea. Maybe you don't agree with the whole statement, but what do you make of it?
Well, I think if you study history, it certainly proved true that in that instance, it was definitely a boneheaded idea. President Franklin Roosevelt suffered many political defeats. Even his own party was not in favor of packing the court for the reasons that you guys have been discussing. It would transform the Supreme Court into a partisan political institution if we were to pack it with new justices every time a new president and Congress were sworn in. It just really sort of inverts the constitutional design to have a Supreme Court that grows with each new election. So I think he's absolutely right. It doesn't make any sense. In Article 3, we see that the founders intentionally created the third branch to be different. Article 1 provides for the election of Congress. Article 2 provides for the election of the president through the Electoral College. And yet, in Article 3, as you all have been discussing, the process is very different. The president appoints, the Senate confirms, but then after that, the judges have lifetime tenure precisely so that they can institute the rule of law, so that they can serve as a check on those elected branches.
Sorry, so thank you, Erin. No, I wanted to ask you, I know you've written about this, but one of the arguments that people make in favor of packing the Supreme Court is that there should be balance. So they say, well, there are too many Republican appointed justices right now. We need to expand the court to bring it back into balance, like a political commission, like the Civil Rights Commission on which I served, or some other commissions where there are a certain number of Democrats and a certain number of Republican appointees at any one time. I know you've written a couple of articles debunking that, but I wonder if you could explain to our audience why that doesn't make sense in this context.
Absolutely. Well, I think, Jennifer, the whole idea of balance on the Supreme Court really just gets their job wrong. It gets the idea of what a Supreme Court and an Article 3 judge is supposed to do wrong. And that is that, as Mike was talking about, we have, for the first time in quite a while, a constitutionalist court. And what Mike means by that, I believe, is that we have a court that believes that words matter. And that the Constitution matters, and that federal judges should interpret the Constitution according to the words that are in the Constitution, according to the history that the Constitution, the history at the time the Constitution was enacted. And when we're looking at a statute, the question should be, what is it that Congress wrote? We don't want judges who go in, look at a statute and say, I think we should redline it a little bit. I think we should blue pencil it. And I think that we should change it because times have changed, or I just think I know better than the elected branches. We know they're sometimes dysfunctional. We should be able to correct that. And I think that's the idea behind this notion of balance, is that we need some Republican judges, we need some Democrat judges, so they sort of come to the right policy conclusion together. But that idea, again, is contrary to the idea of a judge who is supposed to interpret the law as written, not as he or she would like to write it or think the best policy decision is. So really balance has no place on the court. It's not about balance, but about the rule of law.
Erin, I'm glad you said that, because I think, as we've discussed, people have difficulty separating where politics should be involved in this process, right? i.e., that it should be involved in the initial confirmation process and the appointment process. We don't want a court that's completely disconnected from the people, right? There's a reason we want this attenuated connection to small d democratic politics. But as you rightly say, that connection and that influence is supposed to stop at the court door. Do you worry that just proposing some of these ideas and running them through Congress and having the president have a commission to discuss what he calls reform, do you worry that in itself may be enough to essentially politicize the court, to put political pressure on the court?
I certainly hope not. And I think our justices are committed to doing their level best to rule in a way that's consistent with the rule of law. But I don't doubt that some of these proposals are initiated in order to put pressure on the Supreme Court. If we look back at history again and to Franklin Roosevelt's plan, there was in the New Deal, he was proposing and Congress was enacting these massive governmental programs, and the Supreme Court was striking them down as inconsistent with the Constitution. Then President Roosevelt proposes packing the court. His plan was for every justice, as Mike said, over 70. He was going to get to add a new justice, which some justices were elderly. He was going to get to pack the court. And what happened was that the Supreme Court actually started ruling his way. The historians call it the switch in time that saved 9. And so the court wasn't packed, but they did start ruling and upholding his legislation. So I think from that example and from some of the way these proposals are bandied about, there's no doubt that it is intended to sort of, in a sense, threaten or at least tell the court, hey, if you don't pay attention, we're just going to add new justices who will rule the way that we want you to.
So, Mike, you worked on the Hill. I want to ask you a little bit about the politics of this. Biden said in the clip that we just played that he thinks or thought court packing was a bonehead idea. So why did he establish the commission, and do you think he's honestly changed his mind? And related to that, you think about this piece in your answer, some members of the House of Representatives and the Senate are angry with Biden for establishing the commission because they think that this is his way of punting. So they've introduced their own legislation to move forward with court packing without study. And I wonder if you could sort of comment on that political side of it.
I almost wish that the Republicans in the House of Representatives would get a discharge petition. Maybe they can get all 215 Republicans or whatever it is, and maybe get like the squad to join a discharge petition so we can get 218 people to sign this discharge petition and force the House Democrats to vote on court packing. And then maybe we can do an amendments in the Senate and force Senate Democrats to vote on court packing. Because I'll tell you what, it's not a winning issue for Democrats. It's a horrible political issue for them. We saw this even in the last election where Republicans, I have to be careful, I can't be partisan on here as an Article 3 project representative, but Republicans in the Senate kept a lot of seats that Republicans should have lost. And a big driving reason for that is court packing. So there were, court packing was certainly a benefit to Republicans, Senate incumbents this last election. Think about this. Democrats ran on the Supreme Court in 2016, and President Trump won an upset victory over Hillary Clinton, in big part over the Supreme Court vacancy. In 2018, the Democrats ran on their Me Too allegations against Justice Kavanaugh, and we ended up sending 4 Democrat incumbents packing. They lost re-election over that issue. And again, like I just said, in 2020, there were a lot of Republicans who held on to their seats because of court packing and the assault on judicial independence. I think it is a hugely stupid political issue for Democrats to be pushing this, and so I hope that they do it.
You might call it boneheaded.
Yeah.
It's funny to me that they think that they can get away with this politically, given the fact that obviously when FDR tried this, he earned a huge rebuke, even from his own party. It was wildly unpopular. And this is a president who was ultimately went on to be elected 4 times, right? He was massively more popular than Joe Biden is now. And yet this particular plank of his agenda was extremely unpopular. In a subsequent election, Democrats lost 6 Senate seats, 71 House seats, a dozen governorships. This was really the one. I wish that the country had rebuked FDR for more, but this was really a sort of solitary moment of rebuke for a wildly popular president. Actually, let's bring up this clip of Trey Gowdy referencing, I think, some of what you said, Mike, about how this could actually be a benefit for Republicans.
Brett, this is a gift from God. That is the only way to describe it. It has no chance ever of becoming law with the current Congress, but it will be used to bludgeon Democrat candidates in 2022, which is why you saw that motley group of only 4 that can't even wait for Biden's commission. So Republicans rejoice that Jerry Nadler is handling strategy for 2022. You're guaranteed to retake the House and the Senate.
So I actually worry about moving the Overton window on this issue, even though it might be sort of a short-term boon to the party. Do you guys worry that even though it might be a sort of short-term, whatever, political victory, right, as you say, Mike, to get all these folks to vote on it, on an unpopular proposal, don't you worry about shifting the Overton window? Isn't this just going to become, as everything has moved from the fringes of the Democratic Party into the mainstream of the Democratic Party, and by the next election we'll be, debating this?
Erin, go ahead.
I hope not, and I'd be curious as to what Mike thinks on this. But there really is no principled reason to pack the court. That there's none. The court is not overworked. It actually is deciding fewer cases today with more help than at almost any time in its history. If you look back even as recently as 1980, the Supreme Court was deciding about 150 cases. Currently, it has maybe 60 or 70 cases that it decides per year. Sometimes you see statistics that the court handles 10,000 cases a year. But that's really misleading, because most of those are cert petitions, and the vast majority of those cert petitions have zero chance that the Supreme Court is ever going to hear that case. So the court is not overworked. As Mike ably explained, there's no circuit riding. We don't have Chief Justice Marshall who's getting thrown off his horse anymore. I think it was a carriage. And he actually broke his collarbone. That just doesn't happen today. So that there's no reason.
But it would be really entertaining to see the Supreme Court justices today ride out on horses. I would pay for that. Continue, please.
Justice Ginsburg and Justice Scalia, of course, did ride an elephant. There's that famous picture. But they're not riding circuit. They're not overworked. There's just no principled reason in order to pack the court. So my secret hope is that this commission is just a place where this court packing proposal can go to die. Because there's no reason to recommend it. I might be wrong on that. The commission may be overwhelmed with partisans who really want to see the court change course and are willing to add justices to do so. But I'm hoping that this Supreme Court commission actually just buries this proposal.
What do you think, Mike?
So here's the deal. If we didn't have senators, Democrat senators like Joe Manchin and Kyrsten Sinema come out and say that they're not going to nuke the legislative filibuster, the Democrats would absolutely have nuked the legislative filibuster that we've had since the 1830s, meaning they would lower the vote threshold from a supermajority requirement to a mere majority requirement. They would lower it from 60 to 50 votes plus Kamala Harris breaking the tie. They absolutely would pack the Supreme Court. They absolutely would add new states, DC, Puerto Rico, who knows? We have 5 territories. Who knows where it would end? They would add 2 new senators for each state. They absolutely would pass H.R. 1, which is a federal takeover over our elections, to ensure that Republicans never win key elections again. And there goes our First Amendment right to speak, our First Amendment right to associate, our First Amendment right to worship, our Second Amendment right to keep and bear arms. Our rights would go out the window if Democrats nuke the legislative filibuster and pack the Supreme Court. So it is a very dangerous, revolutionary idea. Thankfully, like I said, we have 2 adults left in the Democrat Party in the Senate, Joe Manchin and Kyrsten Sinema. Otherwise, we would be having a much different discussion right now.
But Mike, why do you think that Biden set up this commission? Is he punting? Does he want to pack the court, or does he still believe it's a bonehead idea? I mean, I'm sort of with Inez on this. I think that he set up the commission to change the terms of the debate, to make it more palatable down the road, not necessarily to do it now. And frankly, I worry that the whole commission is actually sort of a sideshow. That even though Biden may have no intention of expanding the court now, that what he'll do is recommend maybe term limits, use the commission to recommend term limits for Supreme Court justices, or just distract the public with this whole Supreme Court debate and then quietly expand and pack the lower courts without any objection from the public. I want to actually ask you about both of those, both of those things, term limits for justices and packing the lower courts. But let's start with the term limits question. Yeah. This has actually received some degree of support from conservatives and libertarians. Here's a clip of our friend Elias Shapiro from the Cato Institute talking about this issue.
I want to offer 2 cheers for term limits. In other words, I'm not a full-throated, term limits are the greatest thing since sliced bread and would fix everything that anyone thinks is wrong with the Supreme Court or America. But I do think it would be helpful and healthy. The death of Ruth Bader Ginsburg prompted once again a wave of discussion about the idea of limiting the term of Supreme Court justices. If only RBG had been forced to retire years ago, the theory goes, the country would not have faced a bitter confirmation fight in the midst of an already tumultuous election season. The hope, which first gained traction in modern times after Robert Bork's failed nomination in 1987, is that by more regularly replacing longtime justices with newer ones, adding predictability to when those switches occur, the nomination process would become less divisive and disruptive. I think that's largely right. Term limits could help restore confidence in the confirmation process and eliminate the morbid health watches we now have as justices age.
So, Erin, let's start with your reaction to Ilya's 2 cheers for term limits. Do you have 3 cheers, 2 cheers, no cheers?
Maybe 1 cheer. It's certainly absolutely 100% better than packing the court. So there's no question that term limits is a better proposal than packing the court, because packing the court, by definition, would give this president the ability to appoint, the current proposal floating around is 13 justices. So nearly 50% more justices in a single term by a single president. If you had term limits instead, presumably those would be staggered based on the ages of the justices. So you would not have as much potential for the court to go through radical changes in order to just change the way it rules. So it's much better than court packing. On the other hand, it would require a constitutional amendment. So as we've talked about, the framers clearly envisioned that the court would be insulated from politics once the justices were confirmed. And the reason being so that they would be able to follow the rule of law, not be swayed by politics or political pressure. And that is why they are given lifetime tenure under Article 3. If we were to change this, it would require a constitutional amendment. And I would want to make sure that those term limits were long enough that the original Article 3 purpose of allowing justices to be insulated would still apply. So those term limits would need to be pretty long.
So there are some people who say that a constitutional amendment isn't required so long as they were to remain on the bench and these judges would be sent back to the circuit courts. I don't happen to agree with that. What do you think, Mike?
That must be Brian Fallon at Demand Justice, who came up with this creative, the non-lawyer has come up with this creative legal arguments, and it just happened to coincide with when President Trump transformed the Supreme Court to the first true constitutional Supreme Court in 80 years. So it's amazing that these same Democrat operatives have not called for packing the Supreme Court in term limits when it was Democrats who controlled, or the leftists who controlled the Supreme Court for so long, when Democrats controlled the court. So this is all politics. Lifetime tenure, as Erin said, is in the Constitution. It's there for a reason. We have lifetime tenure and pay protection so judges can focus on their job and not worry about their next job. Their sole job is to find the law and apply it, to interpret the law as written, and they should not have to worry about the politics. That's, again, why we give them lifetime tenure and pay protection. And the system has worked out very well. It's unfortunate that the Democrats lost a seat with Justice Ginsburg's passing, but that's happened in our history before. It's the composition of the court changes over time, and that's just the way it works. And I think the better argument for people who want to depoliticize the Supreme Court is to get judges out of the politics business, get judges out of the legislation business. Judges have a very critical, it's a very modest but very critical role, and it's to interpret the law. And that's all they need to do. And if they stay out of the politics and they stay out of the policy and they stay out of the legislation, they don't need to worry about any of this stuff. Just follow the law. And think about it this way: if you're a litigant going before a judge, and you don't think you're getting a fair hearing because that judge has a constituency other than the law, or that judge has made a commitment to Planned Parenthood or some other outside group before their confirmation, I mean, that's not the rule of law. That's a banana republic. We need judges to follow the law. And Erin and I have both talked about constitutionalist judges intentionally. We don't want liberal judicial activists, and we don't want conservative judicial activists. If the law is liberal, it's going to be a liberal result. If the law is conservative, it's going to be a conservative result. It's our elected officials. Erin's husband's one of them in the Senate. It's our elected officials' job to make the law, and if we don't like it, we can throw them out of office. You can't throw judges out if you don't like the law.
Yeah, and the reason you can tell, or one of the many reasons you can tell this is not a good faith effort, is, of course, if we were really talking about sort of apolitical reform of the Supreme Court, or doing something that would actually help the caseload, we would be talking about how big the Ninth Circuit is and how people in, widely far-flung states have to essentially play second fiddle to California with regard to that circuit. But I do want to get both of your views on the other issue that Jennifer raised, which is twofold, and then added something to it. One, the expansion of the lower courts, right? So I'm with Jennifer. I'm worried that even though this won't happen, I said I'm worried about the Overton window. I'm worried about the influence on the Supreme Court. But it seems like the consensus is this is unlikely to happen. It may even be a boon politically for Republicans in Congress just because it's so unpopular. But is this just a cover, kind of putting the least popular idea out there into the ether to sort of normalize it, get all those nice Atlantic and New York Times pieces on it, when quietly what they'll really do is something that the average American is not paying attention to, which is the expansion of the lower federal courts? And I just want to add one more wrinkle to that before I get both of your opinions on this. There's also apparently in HR 1, there is a proposal to, I guess the Wall Street Journal called it court picking instead of court packing, to route all First Amendment cases through the DC circuit rather than in their respective geographical circuits, either the appeal circuits or the lower federal court. So Erin, if you could speak to any one of those questions that you would like, either the expansion and the quote unquote packing of the lower federal courts and why that could be an issue that flies under the radar, or this idea of just routing more and more stuff through a particular court in DC, even though there's no reason, like there might be for administrative law, to route all that stuff through just the single DC circuit.
Yeah, absolutely. I'll start with the latter one first, and then Mike take the lower courts. But to me, it's crazy to this idea that you might court pick, especially for the idea is for First Amendment cases. So it's absolutely true that if we're talking about patent law, or if we're talking about veterans benefits, if we are talking about certain claims for money against the United States, then those cases go to the federal circuit, sort of a specialized court for dealing with those types of things like patents. However, if we're talking about something that's sort of ubiquitous under the Constitution, like the First Amendment, it certainly seems to be wiser policy to have all of the courts of appeals weighing in. That way you can get the benefit from different judges, get their different views before the case goes up to the Supreme Court or the issue goes up to the Supreme Court. So I think it's a very bad idea to think about picking a particular circuit, presumably a favorable circuit, for certain issues when certain parties are in power.
I would say the reason the Democrats are pushing this, let's just play raw political politics here. They were in 2013, Democrats nuked the filibuster to stack the DC circuit with Obama appointed liberals. So Democrats control the DC circuit. And so that's why Democrats now want all of these First Amendment challenges by Christians and conservatives to go through the DC circuit, where they're going to get kicked out of court, right? And so think about it this way. Think about the political firestorm and the rightful political firestorm. If Democrats said that we're going to have civil rights cases around the country for, discrimination against, African Americans have to go through a certain court. They couldn't go through their courts back home. They couldn't go through the 8th Circuit in my home state of Iowa. They had to spend the money and get the lawyers to go out to Washington, D.C. to litigate their claims. There would be rightful outrage. So why should we put Christians at a worse position than other Americans when it comes to their First Amendment rights? And that's what they're trying to do there by court picking. And the reason you're hearing this is because President Trump, not only did he transform the Supreme Court to the 5-4 Clarence Thomas Court, he transformed the lower courts. We have 13 circuits around the country that divide up the work, mostly by region, 11 by region, actually 12 by region, and 1 by the patents and other issues that Erin was talking about. So we have these courts around the country. When President Trump took office, for example, on the 9th Circuit, 29 seat, once out of whack 9th Circuit, there were 11 more Democrat-appointed judges than Republicans. That got down to just 3. So conservatives are actually starting to get a fair shake in the 9th Circuit, and President Trump flipped the 2nd, 3rd, and 11th Circuit from majority Democrat appointed to majority Republican appointed. So we're starting to see a majority of the circuits around the country that actually have constitutionalist judges who are going to follow the law instead of being left-wing judicial activists, and the Democrats don't like that. And so that's why you're hearing these calls to court pick so they can send people to liberal judges in D.C. and to pack the lower court so they can undo the great work that President Trump, Senate Majority Leader Mitch McConnell, my former boss Chuck Grassley, the former Judiciary Committee Chairman, and then Lindsey Graham, the subsequent Senate Judiciary Committee Chairman. That's why you're hearing about packing the lower courts. It's purely about politics and power.
Yeah, it is, but they have on their side the Judicial Conference of the United States, which in March recommended adding 79 new judgeships, ostensibly to reduce judicial workload and improve the administration of justice. 79 judgeships is a lot of judgeships. How do you argue against that when all of the oxygen in the room is being sucked over here to talk about the Supreme Court and reform of the Supreme Court and the Commission on the one hand, and on the other hand, when you have a supposedly neutral body like the Judicial Conference recommending, saying we need this in order to process cases faster. How do you explain to the public and make them care about this as equally as important?
I would just say, look at the numbers. When I was the chief counsel for nominations to then Senate Judiciary Committee Chairman Chuck Grassley for President Trump's first 2 years in office, I was responsible for oversight over the federal judiciary. And the Judicial Conference is always asking for, just like any other government agency, they're always asking for more money, more resources. So that's not surprising. I have less of a problem with new district court judges, although I don't even know if those are even necessary. It's the circuit courts that are completely unnecessary.
I'm going to jump in and disagree with you there, because the district court judges are where most cases are heard, and that also becomes our bench for appointing appellate court judges, our bench for appointing Supreme Court justices, right? And so I think we don't want to be putting judicial activists into those roles, which is why they want to add these seats, so they can put judicial activists even into the district court slots that they're then grooming.
I don't think that we need to add additional seats, and maybe the handful of districts that we can probably count on one hand where we may need to consider adding new seats. We can fix that by having visiting judges. You can have federal circuit judges, the judges on the federal courts of appeals who certainly are not overworked, go sit by designation on these district courts. You can have district judges that are in districts where they're just not busy, go take these cases. They can go sit by designation. They can go visit these.
And a lot of them do. A lot of them do.
You can go visit these districts and help with the caseload and get the caseload down. Now, there might be, 1, 2, 3, 4, maybe 5 districts where they're truly overworked, and we can look at those. But the problem is that once you open the Pandora's box, once you say, okay, senators, members of the House, we're going to start adding districts, every senator who gets to hand select these district court judges wants to add judges. This is why my former boss, Chuck Grassley, doesn't want to do this, because it becomes a spending spree. You open up the Pandora's box, and all of a sudden you have you have more judges than you have defendants in federal court.
Right.
We just don't need them.
Well, the one person who seems to sort of have a handle on this up on the Hill is Darrell Issa, who at least says, if you're going to do this, you have to stagger it. If you're going to add 80 new judges, you have to stagger them a couple a year over the course of a decade or so, because you can't allow one president and one party to appoint 80 new judges.
Where were the Democrats when the same judicial conference made these recommendations to add judges when President Trump ran the White House and Republicans had the Senate? Crickets out of the Democrats. Now all of a sudden there's this urgent need. It's bogus. It's a bogus political argument.
Well, we're coming to the end of our broadcast here, so I just want to wrap it up with taking it back out to the big picture. Judicial independence and the rule of law is not a universal part of the human experience, right? We've certainly had and continue to have across the world various governments that are more governments of men than governments of law, right? And lack of judicial independence has been a huge part of that. I'm thinking even, in Poland, there's huge political debates over how to restructure the judiciary because their constitution, although based partially on ours, partially on some other constitutions where they had to rewrite it after communism, didn't really provide for various sort of issues within the judiciary that would arise if certain political conflicts came to be. Whereas we've had, well over 200 years to work out some of these norms so that even things that are not explicitly written out in the Constitution, we've sort of confronted them one at a time. I'm thinking here, for example, of judicial impeachment, which was much more a live issue in the founding of the Republic, and then sort of died as people realized, oh, wait, this is going to be super, super political, and we don't really want to use this tool. Why don't both of you, starting with Mike and then go to Erin to close us out, why is this issue so important? This issue, not just of court packing, but of judicial independence, of the independent branch that deals with the law and the rule of law that is at least attenuated from our day-to-day politics. What do we lose if we lose that?
So another one of my former bosses, Justice Gorsuch, talks about this in his book, A Republic If You Can Keep It. So I'm plugging his book now. So North Korea has the most wonderful constitution on the planet. You have a right to happiness in North Korea. It is a magical place on paper.
Not just the pursuit. You're right. You have a right to happiness.
You have the right to happiness. It's not like our Declaration of Independence that the pursuit of happiness, but it's the right to happiness in North Korea. And it, like I said, on paper, North Korea is awesome. Until you realize that they don't have a rule of law. They do not have an independent judiciary. They do not have the separation of powers. So these rights are meaningless. These rights go away if they're politically interfering with the ruling class, that the rights go away. And that's what's going to happen in America if we lose our independent federal judiciary, if we lose independent judges, if we pack the Supreme Court, if we have term limits, if we have impeachment, if we have jurisdiction stripping, these radical assaults on judicial independence are going to affect each and every one of our rights. We saw this, like I said, with COVID. Churches, mosques, synagogues, houses of worship. Erin knows about this very well. These houses of worship are closed down with arbitrary COVID fiats by these politicians who are not following the science. The only thing that had them reopened are 5 justices on the Supreme Court, 5 constitutional justices on the Supreme Court who understand the importance of the rule of law and an independent judiciary.
Absolutely. I think we have someone in the background who's protesting court packing.
That must be at your house.
That's because Erin is Superwoman and she is juggling mom duties and talking about administrative law, the Supreme Court, the future of our republic. Go on, Erin.
So yes, Abigail hates court packing. And I think she's very correct. And as Mike was saying, it really is an assault on the entire separation of powers that the founders envisioned. And if you think about it, the Bill of Rights actually were added later in time. And the reason this was so is because the founders were convinced that these checks and balances that are laid out in the Constitution would be sufficient to protect the rights of the American people. And this is because of judicial independence. The founders believed that the judiciary would be a check against sort of majority excesses, majority rules for their trampling on others' rights. And the COVID cases are a really great example of this. To quote Mike's former boss, Justice Gorsuch, it is not consistent with the Constitution when you have casinos that are open in Las Vegas, but churches remain closed. And without the Supreme Court, without 5 justices, as Mike said, that case actually lost the first one around. The churches were required to remain closed while casinos were open. There was a dissent by Justice Gorsuch, and then later, after the appointment of Justice Amy Coney Barrett, then the Supreme Court switched its view on that and actually held that governments have to be neutral. If the government is going to close things because of COVID, then it can't treat religious bodies, churches and synagogues and the like worse. And without judicial independence, we don't get that. We have governments that can trample on the rights of Americans.
Couldn't have said it better ourselves. Thank you both, Mike, Erin, for joining us at the bar. And thank you to all of our listeners out there. Thanks for tuning in to another episode of At the Bar, where we discuss the intersection of the law, culture, and politics. This is a product of the Independent Women's Forum. You can visit all of our stuff at iwf.org. And then, Jennifer, if you could talk a little bit about the Law Center before we close it out.
Yeah, Erin and I work together in the Law Center. You can find our stuff also on the IWF website. And everybody should also go to Mike's website. It's a3p.org.
Article number 3project.org. Article3project.org.
You can learn more about all of these issues there, and also on Independent Women's Voice, iwv.org. Thanks for joining us. Cheers.
Cheers. I finished mine. I'm done.
Enjoy.
Bye, everybody.